You lost your crypto to a scam. The exchange said it's gone forever. The police said blockchain is irreversible. But there's a legal option that could recover your stolen assets, and many victims don't know about it. In the next 4 minutes, I'm showing you the 3 recovery pathways that actually work, including the civil litigation strategy that recovered over $520,000 for one victim. Most people think crypto is irreversible, but the truth is, blockchain creates a permanent, traceable record, and courts have the power to freeze those records, identify the perpetrators, and force recovery. Here's how this actually works. A court issues what's called a freezing injunction, a legal order that stops fraudsters from moving your stolen crypto. Think of it like locking down a bank account. Simple, powerful, legal. When victims report crypto fraud, law enforcement says it's civil, not criminal. When they ask lawyers, they hear blockchain is immutable. But this handoff leaves victims in the dark about the one legal option that actually works. First pathway, civil litigation. Unlike criminal prosecution where the government acts, you can sue the fraudster, and courts have powerful tools to freeze their wallets and force recovery. Here's how it works. A court issues a freezing injunction that stops fraudsters from moving your stolen crypto, and here's the breakthrough. You don't need to know the perpetrator's identity. You freeze the wallet. English courts developed an innovative legal tool called persons unknown freezing orders. Here's why this is powerful. Emphasize, courts can issue worldwide freeze orders against the wallets themselves, not against the perpetrators. This means you don't need to know who scammed you. You freeze the wallet, and the system forces exchanges to identify the thief for you. That's the breakthrough. Once the wallet is frozen, courts compel the exchange to identify the account holder. These bankers' trust orders force Binance, Kraken, Huobi to reveal who's behind the wallet. 80-year-old Mr. A lost $520,000 to a crypto scam. Using civil litigation under UK law, his lawyers froze the wallet, forced the exchange to disclose, and recovered every penny. Consider Mr. X, a farmer who lost 11.86 Bitcoin, essentially his life savings, when scammers convinced him to grant them remote computer access. Over months, he drained his personal loans and sold his vintage car collection to cover losses. His legal team froze the perpetrator's account. And here's what happened. The mere threat of legal exposure forced the scammers to return every Bitcoin. They realized they were exposed. But what if you can't pursue civil litigation? Maybe the assets have already been seized by law enforcement. That's where Pathway 2 comes in. Federal remission. When the U.S. Secret Service seizes crypto from scammers, the DOJ holds it in an evidence account. And here's where most victims go wrong. They think the government keeps it. Wrong. You can file what's called a remission petition, a formal claim, and the DOJ will literally pay you from that seized pool. You don't need a lawyer, you just need documentation. Here's what most victims don't know. The DOJ's money laundering and asset recovery section will literally compensate you from seized pools. You prove your loss, you prove the connection, you get paid. In 2024, the U.S. Secret Service seized $225.3 million in stolen USDT. This wasn't a one-off. Victims who file remission claims receive pro rata shares of these recovered pools. Now, Pathway 3 is for the more aggressive recovery strategy. Judicial restoration. This is different from remission. Here, you actively contest the federal seizure in court. You argue the assets belong to you, not the government. You litigate it out. And when you win, you don't just get compensated. You potentially recover the actual crypto, worth far more if Bitcoin appreciated since the theft. Why don't more victims pursue this? Lawyers rarely mention it, police don't know about it, and victims think blockchain is forever. Think civil litigation is too expensive. It's not. Litigation funding firms finance your entire lawsuit. You pay nothing up front. They take a percentage of recovery, typically 15-35%. Think you need the perpetrator in your country? Wrong. English courts issue worldwide freezing orders. U.S. federal courts do the same. Jurisdiction is not a barrier. Recovery is most likely when assets traced to regulated exchanges, perpetrator is identifiable, losses exceed $100,000, and law enforcement is already engaged. Recovery fails when funds go through privacy mixes, are converted to cash before seizure, or the perpetrator is in a no extradition jurisdiction, but even these have options. Here are 7 typical steps that can support recovery efforts. Step 1, within days of realizing you're scammed, gather everything. Transaction IDs, wallet addresses, all communications, bank statements, screenshots. Pause for emphasis. This is your evidence, because in court, evidence is power. Professional caveat tone. Note, your specific case may require different steps. Consult your attorney. Step 2. Use blockchain forensics to determine where your stolen funds moved, which exchanges hold them, which wallets. This tracing is crucial, and lawyers cover the cost. Step 3. Talk to a lawyer who specializes in crypto fraud recovery, not your local attorney, someone who's handled freezing orders and knows the pathway. Step 4. Your lawyer files for a freezing injunction and proprietary relief. Courts can act fast when fraud is obvious and assets risk disappearing. Step 5. Disclosure orders force exchanges to identify the wallet account holder. Then they become the defendant in your lawsuit. Step 6. Your case settles through negotiation or the court issues a judgment ordering asset return. Most cases settle when the perpetrator realizes they're exposed. Step 7. If law enforcement seized related assets, file a remission petition with the DOJ, provide documentation of your loss, and claim your share. Here's what changed in 2025. The DOJ announced a new policy. They're now prioritizing victim compensation over criminal prosecution. More seizures, more recovery, more opportunity. How long does recovery take? Civil litigation, 2 to 12 months typically. Remission, 30 to 120 days for the petition to process. Not fast, but irreversible once assets freeze. Successful cases share these traits. Assets traced to regulated exchanges, clear documentation of loss, perpetrator identifiable or wallet documented, and losses over $100,000. Cases struggle when funds go through privacy mixers, convert to cash, or the perpetrator is in a sanctuary jurisdiction. But even here, newer legal tools are emerging.